Amy Goodman, as we continue to look at Texas now, turning to a man facing execution there, despite concerns he was sentenced to death because he's black. Although Duane Buck's guilt is not in question for the 1995 murder of his former girlfriend, Deborah Gardner, and her friend, critics say jurors in his case were led to choose a death sentence over life without parole based on testimony of a state psychologist who argued African-American criminals are more likely to pose a future danger to the public. At a sentencing hearing in May 1997, Walter Quijano, a former chief psychologist for the state prison system who'd evaluated Buck, testified in part that, quote, it's a sad commentary that minorities, Hispanics, and black people are overrepresented in the criminal justice system, unquote. In 2000, then Texas Attorney General John Cornyn said Buck's sentence and 6 other cases merited re-examination because of racially charged statements made by Quijano. But unlike all 5 of the other cases, Buck's case was never reopened. Now the district attorney in Harris County has vowed to set an execution date within 30 days if Duane Buck loses his final appeal, which could be decided any day now. Last week, a statement calling for a new sentencing hearing for Buck was delivered to the Harris County district attorney, Mike Anderson, by Mark W. White, Jr., former Texas governor in the 80s who oversaw 19 executions but opposes Buck's killing. For more, we go to Houston, where we're joined by Linda Geffen, second chair prosecutor who helped win the death sentence for Duane Buck in '97. She now opposes his execution. She is currently senior assistant prosecutor in Harris County Attorney's Office. Here in New York, we're joined by Christina Swarns, attorney who's part of the Duane Buck's legal defense team. She's the director of the NAACP Legal Defense Fund's Criminal Justice Project. We welcome you both to Democracy Now! Linda Geffen, let's go to you. You helped convict Duane Buck. He ended up with the death penalty, being sentenced to death. Why have you changed your view on his case right now?
14 years after the trial, I saw on the internet the offensive testimony in black and white. And when I had the opportunity to read it and to really absorb what it was saying, it was so... I had so much clarity that it was racially offensive, it was egregious, and it was error. So I emailed Mr. Buck's lawyer and asked how I could help.
Talk about what that quote was. I'll read a comment Dr. Quijano made to the New York Times. He said, quote, I was asked a question whether there's a relationship between race and violence or dangerousness. The literature suggests there's a correlation, so I had to say yes, he added. It's not because of the blackness of the person that's causing the violence. It's what goes with it. Poverty, the exposure to lack of education, exposure to criminal elements. Let's go to our guest right here in New York, Christina Swarns, your response to that.
Well, I think Dr. Quijano made quite clear that what he believed and what the state was looking for him to say was that because Mr. Buck was and is African American, he posed a future danger to society. And the prosecution and cross-examination elicited that testimony. They then went on to argue specifically that point during closing argument. What the prosecutor said in closing was Dr. Quijano testified that he would pose a future danger, and that on that basis you should find that he is a future danger and he should be sentenced to death. I would go on to say that, as the New York Times reported, Dr. Quijano's opinion, of course, about this is false. There isn't a real connection to support a future dangerousness finding.
Now, explain, Linda, in Houston, Texas. Can you explain what it is that happened, that 6 cases where Quijano's testimony was involved were all reevaluated? 5 of them, those prisoners who were on death row, ended up with life without parole, except for the case of Duane Buck. What happened?
It appears that then Attorney General John Cornyn became aware of the racial bias that had infected these cases, and he ordered a review of all of these cases that Dr. Quijano testified in. And each case, he gave an opinion that they need a resentencing hearing, and all of them received their hearing except for Mr. Buck. And it's likely, or it seems probable, that that happened because A.G. Cornyn was at the end of his term. He He went on to do other things. The next AG, Greg Abbott,
Cornyn,
came in.
of course, is the current
and
senator from Texas, John Cornyn.
That is true. That is true. And the current AG, Greg Abbott, did not grant the resentencing or recommend the resentencing hearing. It clearly looks that Mr. Buck's case fell through the cracks, which is even more egregious when it's a capital case. No individual, no defendant should ever fall through the cracks of the criminal justice system. But when the ultimate punishment is on the line, it is morally reprehensible.
I want to read from a summary of a study by criminologist Raymond Paternoster that documented racial disparities in Harris County death penalty cases at the time Duane Buck was sentenced to death. He said the likelihood that the district attorney would pursue the death penalty against African defendants was about twice as high as for white defendants, and that, quote, the probability that a jury would impose a death sentence was 0.33 in white defendant cases and increased to 0.438 for black defendants, 1.3 times higher than for white defendants. Christina Swarns, your response.
Yeah, absolutely. I think that what we found was that the incidence of Dr. Quijano and presenting racially biased testimony at this trial was part of it seems to be part of a larger culture. Professor Paternoster found that the Harris County District Attorney's Office was 3 times more likely to seek death for African-American offenders like Mr. Buck than they were for similarly situated white offenders, and that Harris County juries were twice as likely to sentence African-American offenders like Duane Buck to death relative to similarly situated white defendants. So it's clear that this was sort of a larger pattern of discrimination against African-Americans coming out of Harris County. And I would say that that's also further supported by the history in the county. We know that the Harris County District Attorney's Office disproportionately excluded African-American prospective jurors also at the time of Mr. Buck's trial. So there's a lot of evidence, really, of discrimination against African-Americans by that office at the time of Mr. Buck's trial.
I want to play a comment from Phyllis Taylor, Duane Buck's stepsister. She's forgiven Buck for shooting her on the same day of the murder of his ex-girlfriend and her friend, and has called for his life to be spared. In this clip, she describes a recent visit she made to Duane Buck.
He came down from death row to receive his lethal injection sentencing at the county jail, and his sister Monique and I went to visit, and I had a wonderful visit with him. I let him know that through everything that had happened, I found forgiveness within my heart. I went to church and I prayed along with family members and my pastor until I found it in my heart to forgive. So when I was able to talk back with him or through letters of writing, then I let him know that he was forgiven through Christ.
That is Duane Buck's stepsister, Phyllis Taylor. The significance of this, Linda Geffen, in Houston, of one of his victims, she wasn't killed, forgiving him.
I think it's unprecedented. It's huge. Most victims and victims' families of these types of crimes are often out for revenge. But the fact that she was shot in the chest, recovered, and has found it in her heart to forgive him is extremely significant. Look, Harris County has the unfortunate reputation of being the death penalty capital of the world. Now we have a golden moment for Harris County to stand for justice. Phyllis Taylor has forgiven him. There are many elected officials and people in this community who are supporting the new resentencing hearing. Clearly, as you said at the top, that we're not asking for him to be released. That's silly. Just a new colorblind resentencing hearing.
I want to go to the Texas Tribune. I want to talk about his lawyer, Duane Buck's lawyer. They said Jerry Garanot's a Texas public defender noted for his involvement in numerous death penalty cases. In total, Garanot has represented 39 clients facing capital punishment, of which 20 have received the death sentence. His record has attracted significant media controversy considering his ability and the number of cases he was allowed to take on. However, Garanot has maintained the judges routinely assign him the most difficult and horrific cases, often involving multiple murders or the murder of a child. He's been dubbed Death Penalty Express, America's most lethal attorney, and the Undertaker for the state of Texas by various media outlets. You were up against him, Linda Geffen, in this case as you prosecuted Duane Buck. Your response to his representation in the original trial?
I can't comment on the comments in the Texas Tribune. I know that he's a very effective attorney. He had a co-counsel in that case, and I do believe he is frequently appointed to death penalty cases. Here in Harris County, you have to qualify to represent a defendant on a capital case, and he's an effective attorney.
He gained international notoriety in 2009 when his client, Linda Carty, a British citizen charged with murder and sentenced to death, appealed her case to the Supreme Court, claiming incompetent legal counsel. According to a report in the New York Times, Garanot met with her once for only 15 minutes before her trial. The case involving Carty drew much attention about Garanot's career. He no longer handles capital punishment cases. However, the Houston Chronicle reported Garanot handled more than 2,000 criminal cases between 2007 and 2008, more than 12 times the caseload limit accepted by the National Legal Aid and Public Defender Association. Christina Swarns, can you comment further?
Yeah, I think it's quite clear that Mr. Garanot provided Mr. Buck with inadequate representation in this case. Obviously, this is a man that stood by and allowed testimony suggesting that his client's race formed the basis, an appropriate basis of a 5-day.
He brought that psychologist onto the stand.
He did.
Right?
And then when the state elicited this specific link on cross-examination, he did not object. You know, he allowed this testimony to go before the jury in this case. I would add further that he also did an inadequate job in terms of representing Mr. Buck in presenting mitigating evidence. There was an abundance of evidence that the jury should have heard about Mr. Buck's life, about his upbringing, about the adversity that he faced that was absolutely available at the time of his trial but was not presented. Mr. Garanot's record, as described in the articles that you've talked about, as just recounted in the McCarty case, is absolutely reflected also in Mr. Buck's case.
And Christina Swarns, you deal with the issue of the death penalty a lot with the NAACP Legal Defense Fund. How typical is this in terms of representation? And final comment on this case.
In terms of Mr. Garanot, it's an unfortunate reality that capitally charged defendants in this country routinely receive poor counsel. That said, I think this case really is above and beyond the pale with respect to seeing someone facing execution because of the color of their skin. This is a case where that link has been made explicit. That argument was presented to a jury, and the argument was found by the jury and credited by the jury, and this man is now on death row facing execution. Texas promised that no person with this kind of testimony would be executed, and Texas needs to live up to its promise. It needs to honor the promise it made to Mr. Buck, because no one should be executed because of the color of their skin. And if Mr. Buck is executed on that basis, then all of us should be worried.
So explain what happens now in the case of Duane Buck.
The case is now in front of the Court of Criminal Appeals in Texas. We have filed an appeal on Mr. Buck's behalf. The Court of Criminal Appeals can either remand our case to the district court for a hearing and further review of the claims that we've raised, or it can reject or dismiss or deny our appeal and send Mr. Buck's case to the Supreme Court.
Thanks so much for watching this report from Democracy Now!, your daily independent global news hour. We don't accept advertising or corporate funding, but rather rely on donations from viewers like you. Please make your contribution by visiting democracynow.org. We need your support today to keep bringing you this hard-hitting, in-depth reporting.